Hello, Grizzlies, and welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we have a very special guest, the lawyer you know. And if you don't know the lawyer you know, you're going to know who the lawyer you know is, all right, after this. So let's welcome Peter Tragos to the stream.
What's up?
Thank you so much for being here at Grizzly True Crime. Everyone's very excited to see you here. And welcome also to the lawyer you know crew who's here. Thank you, everyone, and thank you, mods, members, everyone, as always. I appreciate it. All right. So we're going to be discussing.
An intro.
It was, right?
That was cool.
We welcome you. The Grizzlies love you. And if you see bear emojis flying in your chats, you'll know why.
Awesome.
Grizzlies will be over there. So you guys, before we dive into the Idaho case, go and subscribe to the lawyer you know. The link will be shared throughout the stream, and I will also put it in the description box and in the pinned comments afterwards for you. So it's really easy to find. We will not be able to get to all your questions today, okay? I've prepared for you guys a presentation with all the questions you already submitted, especially on Patreon. Okay, so what we're going to do is power through those. Peter's only got about 45 minutes or so, okay, so we can't linger too long. But then afterwards, please go there, because a lot of the questions that you'll have are there on those live stream replays. You can see I've been binge watching everything 2 times. So make sure you go replay watch over there as well. Subscribe and say that you're from Grizzly True Crime. Yes. Okay. Are we ready to dive into the Idaho case? I know you're covering lots of cases as well. The Sarah Boone case, Alec Murdaugh. Anything else on the agenda coming up?
We've been doing some Valo Daybell, which has some interesting crossover with this since it's Idaho. It gives us kind of a look ahead, a couple years ahead, alibi defenses, what type of things may come out in this case. So I've been looking into that one as well.
Okay, great. Yeah, great. We've done that here too. So that's some good crossover. You're always welcome here. Just know the door is wide open. Okay, so let's go, you guys. Here we go. Also, if you guys are going to be buying super stickers and things, I'll try to get to them. However, I'll just pop them on the screen so that we don't interrupt the show too much. All right. So first, as you know, you might be impressed with me saying this. As a true crime YouTuber, Bryan C. Kohberger is innocent until proven guilty in a court of law. Now, the question that I have for you is, what does a fair trial look like for Kohberger in your mind?
A fair trial looks like the jury coming into this courtroom, listening to the evidence, and before they hear the evidence, they understand that there is a castle that has to be built. And as you're looking at the castle with no bricks and no blocks, there's no castle there. So as you look at it, you have to say there's no castle, right? Even though you think they're going to build a castle, as you sit there when you walk in, there's no castle, and that has to be your vote that there's no castle there. And you watch, and if they are able to build a castle, then you call it a castle. But if they don't build a castle and all they do is build a door, or all they do is build a moat, you got to say there's no castle there. And if they're missing one of the important parts, then it can no longer be a castle. And that's basically what a fair trial looks like. You cannot come in there thinking you already know what the state is going to prove. You can't come in there thinking based on this profile that Bryan Kohberger is a serial killer and he's committed all these murders and other ones. You would not be a fair juror. You should be disqualified from being on the jury, which I say that to most people in my chat would probably be disqualified if they already know too much about the case and they've heard and watched channels like yours that give them so much information that helps us understand context, some of which may not come in at trial. And if it's not coming in at trial, like some of the mental health statements, and if you know those mental health statements and struggles that Bryan Kohberger went through, you probably shouldn't be on that juror because you may be thinking because of this or that, he's more likely to have done this, which is exactly what our legal system keeps out of trials and out of the eyes of fair jurors. So it's not that they don't have to know, or that they can't know anything about the case, right? They can understand that these murders occurred. They can even have seen news articles or news stations that have talked about these murders and reported on these murders, or known that Bryan Kohberger was arrested for these murders. It's just all of the other details. They have to wait until the state proves them in court before they use them to build that castle or put that puzzle together, or whatever analogy you want to use.
Yes, exactly. And normally when I ask law enforcement professionals, how much does the public really know about a case? They say maybe 5%. Now, in your legal experience, now that we have the probable cause affidavit and all these other documents and things, how much do you think the public now knows about the case?
So how much do they know about the case is a pretty broad question, right? I mean, there's always going to be things. Yeah, there's always going to be things that the lawyers and law enforcement officers know about the case that we will never know as the public. But I think it's probably closer to 50% if we want to give a percentage than 5. We know a lot more than 5%. Now, the other thing is whether or not some of the stuff we know is even considered part of the case. right? So there's all sorts of ways to answer that question that make it difficult. But today's day and age, we know more than ever. We'll put it that way.
Yes, exactly. If you guys want a deeper dive into those old posts, the visual snow posts, and all that kind of stuff, how does that come into play here? Go and check out the Lawyer You Know's latest episode with his dad. Your dad is a criminal defense attorney, right?
Yeah, he was actually the chief of the criminal division here in federal court as a prosecutor back in the 80s. And then he's been a criminal defense lawyer for the past 30 or 40 years.
Wow, yeah. So if you guys want to know more about that, go check out that episode. I'll link everything for you afterwards. So based on this little infographic, they say a preliminary status hearing and a preliminary hearing are two different hearings. So now we know they had the preliminary status hearing and they didn't waive the preliminary hearing. So the next preliminary hearing will happen on June 26th at 9 a.m. At that point, they'll decide if there's no probable cause or probable cause, and then the plea will be entered. So the question here is, who benefits most from this delay? Because it's quite a long time. June 26th, damn. So who benefits most, the prosecution or the defense?
I would say in this case, it would be the defense, because when we talk about how long, and a lot of what brought this case into the public eye was how long the investigation took, right? It was open for a month and then 6 weeks until there was an arrest. The family members of the victims were coming out, trying to push law enforcement, hiring investigators, hiring lawyers of their own to make sure the case didn't go cold. Come to find out with the probable cause affidavit, they've been doing the investigation. They have been methodically working up this case. They are prepared. They are ready when they made their arrest. Now, they're still gaining evidence. They're still gaining documents. They're still doing testing. So the state will still benefit from this delay as well. But if you think about all of the evidence that the state has already gathered in the case that they've built over the last 6 weeks, to have this probable cause hearing in 14 days would put the defense at a disadvantage, which is why they waived that time period and agreed to set it out until June, because now they can use their experts. They've already had experts at the scene doing some reconstructing. They're going to get cell phone experts. They're going to get video experts that can talk about where the car was and whether or not it's the same car and what a ping actually means on a cell phone versus triangulation and whether or not that's actually enough to get to probable cause. And they're going to be able to, even if they don't put that expert testimony on, they will ask those expert witnesses that they have hired, what are the best questions we can ask for the state's experts, and prepare for cross-examination as the state is putting on their evidence in this preliminary hearing. So I think this time to prepare is going to benefit both sides, but more so the defense to catch up with what the prosecution's already done.
Okay, great answer. LYK family member here, first time on this channel. Welcome to everyone. Thank you so much for being here. You are welcome in the Grizzly community. Okay, so in your opinion, is this case a slam dunk?
So it's all relative, right? When I talk about a slam dunk, I don't know if you followed the Daryl Brooks Waukesha Christmas parade case, right?
Yes.
So that's what you call a slam dunk when you have video of the defendant actually committing the crimes, right? That's what you call a slam dunk. Then you can have other cases with video, whether it's Sarah Boone or Kyle Rittenhouse or whatever it may be, where you see the defendant doing certain things, but it's still not a slam dunk because there may be some legal arguments around it, whether it's battered wife syndrome, self-defense, whatever it may be. And then you have a case like this, where we don't have a video of anything, so I wouldn't say it's a slam dunk, but there is a lot of circumstantial evidence that the state is piling up to try to prove this case, and it's the kind of circumstantial evidence that juries usually love. In a day and age where you have CSI, you have true crime, you have all this stuff that people want to see, how are you connecting all these dots? They're using technology, they're using video images, they're using cell phone pings, they're using DNA evidence, all to connect Bryan Kohberger to this case. What they're missing is motive. What they're missing is some arguments of, could there have been another person? Is there someone else with motive and opportunity to have potentially committed this crime? Are there holes in this evidence? How solid is this evidence that we've read in a probable cause affidavit? And it sounds good when a law enforcement officer is explaining it with no cross-examination and no experts on the other side. So while I don't think it's a slam dunk, I do think it's a pretty strong case for the state.
Okay, fantastic. All right, so let's go to the next question. So I've heard your thoughts, but maybe no one has yet. What do you think of Jason LaBar, Kohberger's Pennsylvania extradition attorney, doing so many interviews and sharing so much? I know the gag order wouldn't apply to him because he's in Pennsylvania, not in Idaho. But what are your thoughts on that and these little points I've made? Yeah, they're eager to be exonerated, him saying there's holes in the PCA, and then the witness statements also having, holes in that.
So I would say the way I would put it on his actions doing these interviews is I wouldn't do it myself. But I'm not going to say it rises to the level of sanctioning him or disbarring him or anything like that, because we don't know the context of some of these conversations. I know that at some point he said Bryan's dad was with them in conversations. That could eliminate the attorney-client privilege. Bryan could have authorized him to make these statements, which would then get rid of attorney-client privilege. But the attorney-client privilege does not end just because Bryan Kohberger has a different attorney now representing him. So there is some confidentiality there and privilege in those conversations. I will also say most of what he said has been positive and beneficial to Bryan Kohberger. He hasn't come out and helped the public convict him. If anything, he said social media is convicting him too quickly. He's eager to be exonerated. He's cool, calm, collected, basically, which, people have used both ways. So at least I think he's been overly or mostly positive in the remarks that he's made about Bryan Kohberger. He hasn't done anything to hurt his case unless Bryan Kohberger was going for some diminished capacity. I think some of his comments would make that more difficult based on conversations with Bryan Kohberger immediately after his arrest.
Exactly. Yeah. Thank you. You guys are all agreeing. Okay, so let's continue. The eager to be exonerated. Do you find that comment interesting at all, or is that generally what a suspect might say?
So the interesting part, I'll say, around the context of that statement is that Labar went to Kohberger and told him, hey, I think we need to release a public statement. And together they came up with eager to be exonerated or some form of maintaining innocence. And that, to me, is the interesting part, is that Kohberger didn't necessarily want to come out and say that on his own, but based on his attorney's recommendation, that's the comment they came up with publicly. At this point, it would just point to a not guilty plea, but we'll see if they've got some kind of evidence that proves he didn't do it, like an alibi or, somebody else that they think may have committed the crimes.
Yes. Okay. Great answer. Pernille says, appreciate your legal insight, Peter. Always well spoken and to the point. And thank you, G, for the stream. Thank you all for being here. I hope you'll like the video. Share it as well. Make sure hashtag Grizzly2Crime and hashtag the lawyer you know. Okay. Make sure you subscribe over there. So let's see what I got here for you. So they say investigators found that the 8458 phone did connect to a cell phone tower that provides service to Moscow on November 14, 2022. But investigators do not believe that the 8458 phone was in Moscow on that date. The 8458 phone has not connected to any towers that provide service to Moscow since that date. The question is, does this not imply that the cell tower data is unreliable?
So here's what I'll say. When you first read this, you would think defense attorneys are going to salivate over this. When I first read it, I said, oh, well, then we're going to try to apply this to other things. And there's multiple ways to look at a lot of this evidence, right? What it actually is and what it actually proves, and then how a jury is going to see it. So I would be willing to bet they did not have to put this in here. Okay, let's remember that. They did not have to put this information in the probable cause affidavit. It was not necessary to get over the hurdle to get probable cause for this arrest. They put it in there. I would be willing to bet the FBI agents and the experts that the prosecution is going to use in this case are going to be able to explain the difference between this ping and the other pings that they think are reliable to show that he was by those cell phone towers. However, I do think once you hear an expert from the prosecution say that this ping is not reliable to prove what we're saying it proves in the other cases, that some of them are going to think exactly what you just said. And this maybe is not as reliable as they want us to believe. So I think they're going to have a good explanation for it on the prosecution side, but whether or not it gets through to the jury is another question.
Yes. And then they said Kaylee's dad said that Kohberger was so close to the house in the previous 12 times he was there that his phone touched the Wi-Fi. So what if it's proven that he's actually been inside the house and was given this Wi-Fi password, or that the victims knew him, or that he attended parties there? Do you think that could affect the case?
Sure. So a lot of questions we don't know the answers to at this point. I will say one of the things I've been waiting for, and the big question is, what is the connection between Kohberger and the victims? And if he was at parties there, same friend group, was hanging out, to me, that would be a big step in the right direction for the prosecution, even if it's, he liked one of these female victims, got snubbed, whatever it is. And that's what most people would think, because that's the most common crime of passion, right? Rejection or some kind of fight or breakup or whatever it may be, even if it was only in one party's head. But I think touching the Wi-Fi and statements like that show we really, as lay people, when it comes to expert testimony and things like this, need an explanation to show exactly what that means, exactly where he has to be, what's the range, what's the triangulation, Is he on the Wi-Fi, or is that just a misstatement of saying the pinging one of the cell phone towers and just a misunderstanding of what somebody explained to him? So all of that right now is just a little too fuzzy to get into what it actually proves. But if they can get a connection that he's been at the parties, been in the house, other people have seen him around, that would be a big step in the form of proving motive.
Exactly, yes. And they say locals say that signals throughout the area is spotty. So could the defense try to prove that it was not him deliberately turning his phone off either during or after the homicides? You know, with that long drive he did, all of that.
That's something I thought of too. I've never been to Moscow, Idaho, but I've heard and now I've seen some videos and reports that cell service is not like it is in Tampa, Florida, where I am. And so when you come to something like that, I think that that's definitely going to be one of their arguments. It's one of the really interesting things to me. And as someone like you, who's an expert on true crime and covers a lot of these cases and looks into a lot of these cases and a lot of these figures, is someone a criminal mastermind planning this perfectly, doing all these things, and then leaving one of the biggest pieces of evidence behind? That's something that's not connecting to me, as the public wants to call him with his criminology PhD, and he wiped everything down and there's no blood in his car. There still could be. We realize we don't have all the evidence yet. He turned off his cell phone when he did it, but not the next morning when he drove by the house. He forgot to turn off his cell phone there. Doesn't sound like a criminal mastermind to me.
Right? A genius. That's my question all the time. Is he a dumbass or a genius? I don't know. It's very odd. Okay, so would law enforcement not still need to work through the 22,000 white Hyundai Elantras that they had narrowed their search to in order to properly eliminate other suspects or possibilities?
So that's going to be a line of questioning for the defense. How do you know it was this Elantra? What connected you to this Elantra? Even if it was in the area, did you see if there were any other Elantras in the area? Have you looked to see if there are any other Elantras? Who else has Elantras? Because if they really did go through 22,000, there are probably some other people that the defense can pick out, maybe that have a motive, maybe that know these victims, maybe that have been at the house before, maybe whose cell phone pinged just as many times, if not more, than Bryan Kohberger's around the times that these crimes were committed. So it's going to be an important line of questioning from the defense's side.
Okay, and can the defense use law enforcement's misinformation after November 29th when they already knew that it was a 2015 to 2016 Elantra against them?
That's usually not a successful avenue of questioning unless there were other suspects. You know, if there were 5 suspects at that point and they put in there, it could be Bob Smith, Joe Jones, whatever, then they can go look at Bob Smith and Joe Jones. But just misinforming the public in order to not reveal what's going on in the investigation, I think most jurors would buy that as a reasonable statement by law enforcement in order to get justice in this case.
Yes. Okay. Before I ask the next question, do you have like a buy me a coffee link or something? Because I would like to forward all these super stickers to you because you guys, we can't get to all of them. I've got so many that are prepared all day based on all the questions you've already submitted. So I'm really sorry if you're asking questions and I can't get to them, but I'm just going to pop them on the screen. Do you have some way I could direct them to? Well, I'll come to your chat. That's what I'll do.
Yeah, no, you're good. You're good. I'll try to scroll through some of them and work in these answers to some of these questions as well.
Okay, great. Thank you. Okay, so could the defense argue that Bryan did not come forward about his Elantra because his is not the same model that they've been stating that they were looking for? Huh?
Yeah, I think that's an interesting, and this is how far into the nitpickiness do you want to get as a defense attorney? And we all have to make these decisions when you go forward on these cases is, oh, they said he was 5'10", but Bryan Kohberger is actually 6 foot. They said 2013, it's actually 2015 or whatever it may be. And you have to be careful because then if the state says, do you see what they're trying to do? Use your common sense, members of the jurors. Here are the 2 Elantras in the 2 different years. Tell me if you spot the difference. Mm-hmm. And they're almost the same car. And again, we're dealing with lay witness explanations of what the car looked like, fuzzy video cameras of, it's a white Elantra. What year and model is it? They don't change that often every year. So, I don't think that would be the strongest nitpick to take.
Okay, I like nitpick. They might do that in this case, yes. Could the defense argue that Bryan did not hide or conceal or get rid of the Elantra, that the plate changes were due, and that the trip with his dad was actually planned far in advance? So his flight, which might look like guilt, actually has no sign of guilt. Again, nitpicking.
And this goes back to what I just told you. I think a lot of what he did in this case can go to show he wasn't trying to hide anything. He was living his normal life. He finished his classes. He was grading papers. His dad flew in. They drove back for Christmas break. Nothing was out of the ordinary. He easily could have tried to disappear if he was a criminal mastermind. He could have destroyed the car, abandoned the car somewhere. He could have, there was somebody that said on some chat, I'm hiding in a crap hole in Pennsylvania. He could have tried to disappear. Instead, he literally went back. Where are most college kids during Christmas break? At their parents' house. And that's exactly where he was. So to me, was he hiding? It doesn't really seem like that to me.
Good point, yes. And how long do you think the Elantra and the victims and survivors' vehicles could be in law enforcement's possession?
This I really don't know. It just depends on every jurisdiction is different on how long they take to go through things like this. So, this one I'm not really sure of.
Okay, because Ethan's family released a statement saying that his car, his brother's car, and the golf clubs are still being kept from them, which is quite interesting. I wonder why. I don't know.
Yeah, I would
We
think
don't have
they
the
could be
answers.
potentially evidence in the case.
Yep, it could be. Sharing my birthday honeypot with a grizzly pack. Well, happy birthday. There's 2 people in the chat. I think it's Angela's birthday too. Happy birthday. Thank you for spending your time here with us today. Really appreciate it. Okay, so we're powering through the questions, you guys. So could his long drive in rural areas or rough terrain change the tire tread and then disprove any evidence they gathered here?
I mean, I think they'd have to have an expert explain how that would affect tire tread and what kind of tire tread they're trying to match up with where he parked. Did he park behind the house and walk through the woods to get to the house? Where did he actually stop his car? What tire treads do they have? To me, we'd need a little more context of what evidence they're using before we actually see how this is used.
Yes. Okay. That was just a good point raised in one of my chats. I was like, oh, yeah, because he drove so far afterwards. It was so odd through all these rural areas. That's a good point. Could be.
People from the area in my chat have said notorious spot to ditch weapons is some river on that track that he drove. Who the heck knows?
Snake River, Ted Bundy style, right?
Yeah.
Okay, so the latent shoe print. How will prosecutors try to prove that this was the suspect's shoe print? Because everyone's wearing Vans in the house, just about.
Yeah. So, I mean, again, taken from the chat, which what I love about the chat is they're pretty representative of a diverse group of people in a cross-section of society and potential jurors, right? In whatever jurisdiction they're in, they could potentially be on a jury in this case. And a lot of them seem very convinced that with a shoe print like this, you would be able to prove the way that somebody walks and the way that the tread goes on their Vans, that they would be able to connect this to Bryan Kohberger. And I think that that's possible, but we need to be careful because if we're going to say that, and we take one of Bryan Kohberger's Vans and it doesn't match that, does that prove it wasn't him? Does that prove he wasn't there? Because to me, in a house where tons of college students are walking through there with Vans, somebody sent me a picture of their Vans. He's like, I just watched your video and here are my Vans. And I was at the Bucks game last night and I was like, I'm wearing my Vans at the Bucks game right now. I mean, everybody's got a pair of Vans, especially college kids. And we know that there were tons of college kids in and out of that house. So I think we need to be careful about how much weight we put on some of these pieces of evidence, because I think some of them are a lot stronger than others. And if we try to make every single piece the smoking gun, when it flips and doesn't actually point to Bryan Kohberger, what do we do then with our theory?
Yes, very good point. So they say, what does it mean if it's a latent shoe print, and why are there no other latent shoe prints found in the house?
So my dad did a better explanation of this on our last video. I don't want to butcher it. So I'll say, go check out our video when we talk about the latent shoe print a little bit more.
Let me quickly show them. The Lawyer go subscribe over there. If you go to not videos, live stream, it would be
the second one.
Right?
Yeah, right there.
Second one, right? This one.
Mm-hmm.
Go and click on there, you guys, and watch it. This is my second time. I watched the whole thing, okay? So the second time. So go watch this, you guys, and then you're going to get lots more answers there as well. So that would be more about the latent shoe print and also, the visual snow stuff and how that might come into play or not, because it's 10 years old or so. So what did I say here? If there are other shoe prints, I mean, would they withhold that from the PCA? That's a question everyone asks.
They don't have to put it in there, right?
Yeah.
And I think that that's just going to be something that's obvious. That's not necessarily exculpatory or Brady evidence, as we call it, that would prove his innocence. But that's one of the interesting parts about this entire case is we heard so many leaks about the stacking of DNA and shoe prints and fingerprints and whatever because of how many people had been through there. That's why I don't know how they're going to pick and choose what shoe prints and what DNA evidence they're going to determine is relevant versus not relevant. Now, if you see a knife sheath and it's got DNA on the button of the knife sheath, that's relevant to what's happening in this case. Anything else, I'm going to probably need more than just saying there was a shoe print.
Exactly, yeah. And they said button snap, so it could be on the other side. I always argue that way. It could be on the leather, inside, outside. We don't know, you guys. And I'm just showing this picture here based on that virtual tour because this is one of the busiest areas as well. And there were so many people going in and out of there, so this really could be anybody's shoe print. So I agree with you. Don't put too much weight on the shoe print. Is the witness statement not extremely easy to argue against? Meaning, the bushy eyebrows.
Yeah, extremely easy. I think here's what I would say. We don't know the context and explanation that DM is going to give for her statement. I think that there are plausible explanations. We've gone through a bunch of them. So I do think that it's possible that she has a very good explanation for exactly why she did what she did. But I do think that regardless of what she says, there are going to be things that the defense attorneys are going to be able to use and argue to try and create some reasonable doubt in this case. Either it was, drinking, drugs, some illegal activity going on, why she didn't want to call the cops immediately. Or just there's been multiple body cam footage where they had noise complaints. And if the cops came back again, they said there's going to be a $300 fine. Maybe she was scared of that. But if there's any intoxication, that could bring credibility issues on what she saw, when she saw it, who else might have been there, what might have been different from what she saw. So there are credibility issues there if there are drinking or drugs involved. It's 4 a.m. on a Saturday night in a college town, right? I mean, nobody would be surprised if there was drinking going on. So we have that issue. And then the other side is if she said, well, the reason I didn't call the cops immediately, the reason I wasn't worried is because we have people coming in and out of the house all the time. Well, then that creates issues of, then how do you know that there was anything wrong going on? How do you know that person walking down the stairs did anything nefarious? Even if it was Bryan Kohberger, how do you know he did anything wrong? Maybe he was there meeting up with one of the girls upstairs and he was on his way out, leaving. There's lots of explanations based on how she describes the encounter. So I think it's one of the most important pieces of evidence, and the context around why she did what she did and maybe why she didn't do certain things that she didn't do is going to be really important.
Exactly. Yes. So if they've located the weapon, would they have told the public by now?
They don't have to, but I would have think that they would have. And I think if they do have it, we'll hear about it at the preliminary hearing.
Yes. And if they've not located it, how does this affect the case? If they never locate it?
So there's a saying, no body, no crime. And that usually is very difficult to be successful in a prosecution if there's no body and evidence around the body. It's not quite as unlikely when you don't have the murder weapon, especially if you have a sheath like in this case, and the medical examiner or some expert can match up the length, the size, the edge of the knife that would fit in this sheath and how it matches the wounds on the victim's bodies. So there's ways around it, especially with this sheath that's why it's such a huge piece of evidence where if he was a criminal mastermind, you might as well have left the knife if you're going to leave this right next to the bodies. So that's the part for me where it does make it a little less important to have. It would be better with the murder weapon, of course, especially if it has DNA on it. But without it, at least they do have something.
It's quite odd that it was left there because it's supposed to go on your belt. So I don't know if this guy walked in like holding it. Like, what is going on? It's supposed to go around your belt, never fall off, and then you just open the button, snap. I don't know.
When he's walking down the stairs, if he doesn't have his sheath anymore to put the knife in, did DM see him carrying a knife? Did he put the knife in his pocket? I mean, I would think if you got a sharp knife you're putting in your pocket, that would remind you maybe I should go get the sheath for my knife that I walked in with 15 minutes ago because I've only been here for 15 minutes. So some interesting stuff about this case, which is what makes it intriguing, I think.
Yes, definitely. So here, there was just something I was reading earlier that someone sent me saying DNA research says transferred DNA can stay on an object for 12 months. Can his defense not argue that he sold someone the knife, which is why the DNA is still on the button snap?
Sold, stole, lost. Lots of things can be explained why, somebody else has my knife. And this is why the important part is, again, if we represented Bryan Kohberger, we would have what his story is. Once you have his story, then we'd be able to connect the dots on what can they prove out of his story. I saw somebody ask in the chat as well about proving innocence. Criminal defendants don't have to prove their innocence. They can go on the offensive if they want to, and they have a legitimate story or alibi that they think they have evidence of and want to prove that. And we don't know what his is, right? We don't know if his car was stolen or if he had a roommate that had the keys and had access to the keys and the cell phone. Maybe he was the criminal mastermind and took Bryan Kohberger's phone and pinned it on him or whatever. There's lots of things we just don't know, and we don't know what Bryan Kohberger's story is. So that's what I really think is going to be interesting about. We may not know it until trial. We really may not know it until trial.
Yes. Thank you, Lorraine. Subscribe to Peter's channel. Get over there, Grizzlies. And also thank you earlier to Angela. Thank you for that amazing super sticker. To my 2 favorites in one place. That's so nice. Thank you. Okay, let's get back to this. You see how the time goes, you guys. Half an hour in already. Let's go. Power question. So, DM stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. DM stated she opened the door a second time when she heard what she thought was crying coming from Kernodle's room. DM then said that she heard a male voice say something to the effect of, "It's okay, I'm going to help you." So now my question is, can it not be argued that perhaps Kohberger did stalk the victims and cared about them, and when he heard a noise inside the house, he went inside to help?
It's going to be up to him to explain. If
Right.
that's how he's going to explain how he ended up inside the house, then it's going to be up to the jury as to whether or not they believe it. And again, maybe he walked downstairs and the reason DM didn't call the cops is he looked totally normal, like any other guy that had walked in and out of the house after a party or a late Saturday night there at the university.
Exactly. Wow. Okay. So DM stated, a lot of people ask me about this on email. Maybe you get it too. DM stated she originally went to sleep in her bedroom. What do you think that means? Does it mean she changed her location? Is there a reason that they say in this PCA originally?
I think they mean she went to sleep, woke up, went to sleep again, and they probably mean the first time she tried to go to sleep or the first time she fell asleep, and then there was more later. But again, it's just my interpretation. In a deposition, that's definitely something you would ask the officer. What do you think she meant by originally, or did you translate that in the probable cause affidavit? Did you translate it as originally? And if you did, why? What did you mean by originally?
Very nice. I like that. Actually, DM stated she originally went to sleep in her bedroom. Not that she changed location, but originally went to sleep and then woke up again. Okay, so I say, why can law enforcement not release the 911 call at this point?
I don't know why they still have a lot of things sealed. They still have the search warrant sealed over at Washington State at his residence over there. I mean, I think it's all going to get unsealed eventually, but at this point, they say things like public safety and, investigation, protecting the investigation. But if we've got who they think the bad guy is locked up with no bond, no bail, which again, somebody else in one of the super chats said, if he's innocent, does he still have to stay in prison until the trial? The answer is yes, because of how the standards work in America, that there is enough evidence. It's a heinous enough crime. There's still potential danger for the community. So even though he's presumed innocent, he still has to be held with no bond because he meets those standards based on the crimes and the evidence against him. But if they've got the guy, as they're saying in law enforcement, I don't know what the issue is with public safety for releasing 911 calls, or it could be to protect DM and some of the other victims in this case that weren't victims that passed. So, I mean, there could be reasons for it. And that's one of the things that was in the motion to seal the Washington search warrant was privacy for the victim. So
yes, and they've got those protective orders now, but it's not listing everybody that could have possibly made the 911 call. It's the 2 survivors and then the victims' families, from what I can gather from all the initials. So that's interesting as well. But maybe that's why. Just then, instead of having a protective order for every single person, it's like, okay, protective orders for the obvious ones, not releasing the 911 call. But maybe they will at some point. I'm sure they will at some point. So they say witnesses. Okay, so now with DM and BF, right? What if they don't want to testify? Or if they are found not mentally competent or something because of trauma, do they have to?
So if they're not able to physically or mentally or emotionally, then that potentially could be a reason that they don't testify. But if they just don't want to, the defense can subpoena them to come and testify. The state can subpoena them to come and testify. Now, if they don't want to and the state says, that's fine, we're not going to call you, and the defense doesn't want them because they think it's going to be bad for them, then it is possible that they don't testify.
Okay. Interesting. Good to know. And yes, you guys, if you're only joining now, we are here with Peter Tragos, the lawyer you know. And if you didn't know him, now you know him. So go to his channel. It's called The Lawyer You Know. Subscribe over there and check out some of the live stream replays because there's a wealth of information there. There's so many questions that were already asked that you'll get the answers to over there as well. We have just enough time here today to get through some of these. And thank you for being here. Okay, so let's continue with the rest of this. We're almost there, actually. Okay, so let's see what happened. Detectives believe that on November 12th, the 2 surviving roommates had also been out in the Moscow community separately, but returned home by 1 a.m. So my question is, with law enforcement saying the wrong make of the model of the car, and also saying that the 2 surviving roommates returned home by 1 a.m., but now in the probable cause affidavit saying that BF saw Ethan and Xana at the Sigma Chi party, and they got home at 1:45, and everyone was in their beds or asleep by around 2, which we know some of them were awake. Do you think that that could affect the case at all?
So they're going to have to nail the timeline down. And most prosecutors, when they do their opening statements or when they present the case to the jury for the first time, they like to use a timeline. It's usually helped to compartmentalize in your brain how things happened, when it happened. So I do think it's going to be important to get those timelines straight. Just looking at that one clip, I'd have to look through, the probable cause affidavit to see if I could find some explanation. I'm sure there is one, but if they screwed up on the times, then absolutely, if they said it was 1:00 when it was supposed to be 4:00 or vice versa, that creates a big problem when you come to pinging his cell phone, where he was when he turned it off. So, I mean, the timeline is going to be really important with how they're stacking up all this evidence.
Yes, because there's definitely a little bit of inconsistency with what law
Mhm.
enforcement said. Not that they have to tell the public everything, of course, and they can change their mind or the timeline, but I just wondered about that. And this question is actually answered by what I said earlier. Can Kohberger's sorry. Not really. We're not talking about visual snow here. Can his recent online activity, if it's proven to be him, for instance, by the FBI, count against him in court? I mean, the Papa Roger account, the inside looking, and all that stuff.
So I haven't read through all the Papa Roger stuff, but if they prove that it's him and it's statements made by him that are relevant, that have to do with going to prove or disprove something in this case, then they can come in under a hearsay exception because it's a party opponent. The defendant statements can come in, but it has to be relevant, which we talked about a lot of the mental health stuff, not the Papa Roger stuff specifically, but even the Reddit post about getting into the minds of people that have committed crimes and things like that. Those posts would have to still be relevant to actually proving this case, because if they want to put them up, there's an argument in our judicial system that even if something is relevant, if it is so much more prejudicial than it is probative, it's out. And those Reddit posts, I think, would be so incredibly prejudicial that he wants to see, what people were thinking about before and after, when in reality, he could have really just been doing something for his criminology class. But if the prosecution can prove that it actually does prove something really important in the case, it may come in. But if they're just trying to bring it in to say, oh, this would give him opportunity and understanding on how to commit a crime like this, I don't think that's enough to get over the how prejudicial those statements would be.
Exactly. With some of the Papa Roger accounts, what he was saying, they would be arguing with people about, no, the killer went through the sliding door, and this is why, and this was the knife used and all that. So that could be quite interesting if it is proven to be him.
Sure.
Wouldn't be surprised either way if it's him or not. Okay, so reasonable doubt. It was on my thumbnail, you guys. Big question of all my speculation. Okay, so example, about the SWAT team situation? Possible speculative connection. Or no?
The SWAT team? I don't know what this is.
Yeah, there was a guy who is a former U.S. Army veteran, and there was a SWAT team situation in Pullman, Washington, where he was threatening 2 roommates. He was threatening to kill 2 roommates, and then he was shot after 7 hours. Like a whole
That's
standoff
what
happened.
Kohberger was talking about in the
Yes,
car where he was
yes.
pulled over. Okay.
Yes. So that's what he was talking about. So now there's a lot of speculation online, including myself, connecting some dots of just like, oh my word, imagine if he knew this guy. And my thought is he could pin it on him, or he has a co-conspirator or an accomplice or something. So do you think, because I feel like that is one of the situations that creates reasonable doubt, how much weight do you think that holds? Maybe you have to look more into it.
So I think him arguing that there was a co-conspirator with him is probably not going to help a lot to create reasonable doubt. But if he tries to argue it was somebody else connected with that situation, or it had to be more than one person, and they realized that there's nobody with me that couldn't have been with me, but to commit these crimes against 4 people in this amount of time and to get in and out and not leave any trace, except they happen to leave something that's so perfectly pointed back to me, that could create reasonable doubt if he could come up with some explanation of, this had to be a more than one person crime. And, if we want to believe the statements of was anybody else arrested. So I do think it's possible, but usually jurors believe law enforcement, right?
Uh-huh.
Even more so back in the day than they do now. But usually if law enforcement is saying it was one guy, we got the guy, this is him, it's a really tough argument to say, oh, it was these 2 other people, even though there's no DNA evidence or there's nothing that connects them to these bodies as there is for Bryan Kohberger.
So if YouTubers like myself and, the true crime YouTube community are speculating something, sometimes people say, but you're helping the defense, but hopefully not, right? Because they're going to choose a jury that doesn't know much about the case, right? They're not sitting on YouTube all day watching, right?
Yeah, no, I mean, I do think that probably more lawyers now than ever are watching YouTube videos and seeing what people are saying. But I think they're trying to get more of a vibe of what the general public thinks when it comes to this case. Are they automatically convicting their client? What stories might they be buying more than others? But it's really hard to come up with a theory that they are going to be able to find evidence for or witnesses of that they didn't already think of. So, while it's possible, I really don't think anybody's helping either side very much, except for, tips that people are leaving for prosecutors and, background they may be giving on Bryan Kohberger and things like that. But there are going to be people that do help the defense, right? There are going to be witnesses for Bryan Kohberger, family members for Bryan Kohberger, people that were around that saw this, heard that, whatever it may be. So they're already doing their due diligence, I'm sure, on their side.
And based on that, as you know, there was a TikToker that was recently sued for defamation from that professor because, she was saying that professor is involved in the murders and all that. What would your advice be for all of the true crime community of how not to get sued for defamation when covering cases?
Sure. So what I would say is, just generally speaking, because of course nothing I say on YouTube videos is legal advice. Generally speaking, it's bad to accuse people of something without evidence.
Yes.
To take it a step further, even if you have evidence, it's not a good idea to specifically accuse somebody of a crime if you're not a law enforcement officer or somebody who can do something about it in the jurisdiction in which the crimes were committed. If you have something serious like that, you give it to law enforcement, you send it to law enforcement, you let them do their job. It's totally okay to ask questions, think through things, go through hypotheticals, say what if, say, if this exists, how would it affect the case, just to think through it as a critical thought exercise. All of that stuff is okay. And if it was somebody connected, or if it was somebody that knew him or didn't know him, usually crimes of passion, look at statistics. Most stabbing cases are crimes of passion. They know each other. They're not random, whatever it may be. All of that stuff, I think, is fair game and discussion to learn together, to grow together as a community, to understand this stuff. I think convicting people before trials is a big problem that we have to make sure we don't do. And I like how you started out the video that he's presumed innocent. It's okay to think a lot of this evidence points towards the fact that he did it. It's okay to think that if I was on a jury and I heard this evidence that we're looking at, I'd convict him because this evidence might not come in, right? We have to remember that.
Yeah.
So I think it's okay to do that and to, play juror basically and look at this evidence or say, I would need X, Y, and Z to convict him. Or if the defense put on X, Y, and Z, it'd be really hard for the prosecution to overcome that, even though the defense has no burden. I think those conversations are all good thought exercises to kind of get through if you're interested in and looking into cases like this.
Okay, excellent. So now we're at the 43-minute mark, you guys. And Peter told me he's got about 45 minutes. So we're going to do the rapid fire questions now that you guys have sent in, especially on Patreon. So if you want to submit questions for when I have other guests on the show or when Peter is back on the show, if he wants to join us again, then go to Patreon, right? So one, is referring to suspect vehicle number 1 in the probable cause affidavit. Is that standard practice when there is only one vehicle being investigated?
Yes.
Okay, good to know. Good to know. Doesn't mean there's a number 2, you guys.
No.
Okay. How does the public defender get selected? Is it just random, and when it's your turn, or can they volunteer for a specific case? And if so, does that work? Does a law firm have to do the work so that pro bono hours, they select a lawyer, and then does he think sorry, this is a long question, but does he think this particular lawyer was selected? Like the lawyer he has now. So
okay, so I'll explain it kind of in the public defender realm. The private lawyer is kind of totally different. If it's a court-appointed lawyer, they sign up for these cases and can get picked. It's not pro bono hours. They actually get paid by the state at a pre-negotiated rate per hour. But for the public defender's office, so every public defender's office does it a little bit different, but usually it's either random and, we cycle on, like we have A, B, C, D. So first case goes to A, second case goes to B, C, D. But usually in high-profile cases like this, the assistant public defender will be handpicked by the elected public defender to handle a case like this. And even more so when you have a case like this or the Lori Vallow Chad Daybell case, you probably want to put a death penalty certified lawyer on it, not just any public defender, because there's a good chance they're going to seek the death penalty and you don't want to have to switch lawyers in between. And if it is a public defender, they have a right to a death penalty certified public defender in a case like this.
Actually, that brings me to the question of at what point does the prosecutor have to indicate that they might be seeking the death penalty in this case?
So they have to notify him. I can't remember what the timeline is post arraignment or post plea. It's some number of days after the plea. I can't remember what it is. Plenty of time, though. We'll know. It's not going to be a last second thing.
Okay. And initially when Bryan was arrested in Pennsylvania, the news was stating that he was not allowed to see or speak with his family. Is he now allowed to do so in Idaho?
Yes.
Okay, these records also showed Kohberger wrote an essay that when he applied for an internship with the Pullman Police Department in the fall of 2022, he wrote this essay that he had an interest in assisting rural law enforcement agencies with how to better collect and analyze technological data in public safety operations. Could this be part of why the search warrant has been sealed of his apartment and stated that it could cause harm to the public if released at this time? Because if he was in this program, wouldn't he have access or do ride-alongs with the department?
So I don't think that's a reason that it's sealed. I think the reason that it's sealed was stated pretty plainly in the motion to seal it. Protect the investigation, protect the public from messing up the investigation and keeping a dangerous person out on the streets, and protecting the privacy rights of the victims. I think those are kind of the three main reasons that it was sealed.
Okay, excellent. And off we go to okay, let's power through. In today's generation where social media is everything, where does the line of freedom of speech stop and defamation begin? I think we answered that one, right? That's actually what I asked you earlier. Unless you want to answer that quickly again.
Yeah, I mean, you just got to be careful about what you're saying is a fact, as a matter of fact, calling people out, saying things as truth that you don't know to be truth, and you either know that they're false or reasonably should know that they're false.
Okay, if Kohberger is offered to plead out of the death penalty, do the families of the victims have any say in this? If they all want the prosecutor to go for the death penalty, can a plea still be offered?
So it depends on how the prosecutor's office wants to handle it. Usually they will talk to the families and get the victim's input. They do not have to. This is a decision that's made by the state. It's their resources. They are the, victim in the case, theoretically, the state of Idaho. So they don't have to get the okay from the victim's families, but most prosecutors' office do want to involve the victim's families and get their okay on something like that.
Okay, great. In the discovery request, is the information defense requested in request number 6? Oh, damn. We don't have time for that because I was going to pull it up. Okay, but wait. Address or phone?
I know what they're talking about, though.
Okay. If you can't answer it, go for it.
Yeah, it's standard to get that contact information. They're not going to harass them. They would get disbarred. They would get sanctioned if they were going to harass witnesses. And sometimes the state doesn't even get that or give that information. They can just say the state will produce those witnesses. If they need to talk to them, if they need to take a deposition, the state will set it up, and they don't have to actually have the address and the phone numbers of the state's witnesses or victims that they may call in the case.
Okay. And number 9, was it right for the prosecution to clear out or remove personal belongings from the crime scene and return to the family so early on in the investigation before they even made an arrest?
I mean, this is tough. I would say no. I'd want to preserve everything for as long as possible in order to protect a fair defense. Let them get in there, have their experts look at it, be able to figure if there's anything out in there that may be exculpatory or prove his innocence. So I would say, err on the side of waiting, but I can understand. And we've already had questions about why the car and the golf clubs and all that stuff's taking so long. We really want to protect the investigation, protect the defendant's rights.
Yes. What is the probability of a mistrial due to the crime scene being expanded early on and the amount of people in and out of the house?
So it wouldn't be a mistrial. It would potentially, be the charges dismissed or thrown out because they didn't have a fair opportunity or his constitutional rights were violated. He was not afforded due process in a case like this. I don't think that's going to happen here, though. It's very, very low chances.
Okay. And then 11, how do you find a non-biased jury in such a high-profile case? If you were representing someone on trial for 4 counts of murder and 1 count of burglary and a plea deal was made possible, would you advise taking a plea deal or a full-on trial?
Again, this really goes back to what he says. If he says, oh, this is all a mistake, it was an accident, we got in a fight and I reacted, then maybe you take the plea deal. Even if it's not intentional, you try to not get the death penalty, work out a deal for life or something like that. But if he really says, I wasn't there, I didn't do it, or somebody stole my car or whatever, you really can't advise for somebody to take a deal like this because there's going to be no deal on the table where he walks away from this. He may be able to avoid the death penalty, which that I'm not even sure of, but that's probably the best deal he's ever going to get is 4 life sentences. And for a 28-year-old kid, it'd be tough to advise him to accept that when he's telling you he didn't do it.
Yes, exactly. Did you follow the Anna Walsh case at all? The missing.
I saw a little bit on it, just a little bit, not a ton.
There's breaking news now that Brian Walsh was charged with murder. So there you go, you guys.
So that was an interesting case where, they show how they can arrest somebody for some smaller crime just to hold them because they think they've committed some bigger crime. It was like misleading law enforcement or something is what he was originally arrested with. Then they were able to search the house incident to that arrest. And that's an appropriate search now of the house. Maybe they didn't have enough, like we saw in this case, for a probable cause for an arrest for something more, but it allowed them to search the house, which then allowed them to gain more evidence. And now they can tack on the more serious crime.
Exactly. And before you have to go, I know you got to go. So The Lawyer You Know, you guys, subscribe. Is there anywhere else? Where all can they find you? I know it's listed on your About page, but tell them.
Sure. Yeah. Twitter, Instagram, Facebook, at Tragos Law, my last name, and Law is our handle there. We do most of our stuff on YouTube, though. You can get over there, subscribe, get in the community page. Let me know what you thought of this episode. Maybe I'll come back on here if you guys enjoyed it. If your crew here, the Grizzlies, enjoyed it, then maybe I'll come back here and we can talk about another case.
Yeah, that'll be awesome. So thank you so much for being here today. You guys go subscribe there. The Lawyer You Know, okay? He's at 180K subscribers. Let's make a dent over there. Let's make a dent. Make a 181 at least today. Everyone head over there, and then you are Tragos Law everywhere, right? It's The Lawyer You Know, at Lawyer You Know. Okay, make sure you tag it properly on YouTube, but everywhere else, Tragos Law.
Yep.
Any other closing thoughts before you got to go?
No, that's it. I appreciate you having me on.
Okay, thank you so much. And do you want to chat behind the scenes, or do you want to just like bounce?
Say that again.
Would you like to chat behind the scenes, like after I play the outro, or do you want to just bounce? Because I know you press for time. The reason
I'll probably just take off, but I appreciate it. If you need something, email me. We can talk.
Awesome. Thank you so much for being here, and I'll see you again soon.
All right. Have a good one.
Bye. Okay, Grizzlies, I hope that you enjoyed that. Sorry if I missed all your super stickers and your super chats and everything. I worked all day on that, making the questions that you guys have been asking me to ask. So hope you enjoyed that. And yes, the docket has just shared a message with me saying that Brian Walsh has been charged with murder in the Anna Walsh case. So I really do have to go and catch up on that now, because what? And yes, please go over there, subscribe, and remember to say that you're a Grizzly. You could either show, your bear emoji. You can go there for the next live stream. So if you go to the homepage, let's see if there's anything scheduled. Not right now, but Peter goes live quite often. I hope that you enjoyed that guest here. I would recommend checking out this one right after the stream, because this is him and his dad bouncing back ideas back and forth. His dad is a criminal defense attorney, right? Talking about that visual snow stuff, the post that Bryan Kohberger made, and could that play into, was it premeditated? Could people say, could he do the insanity plea thing, which I don't believe they do in Idaho. So either way, no. But even if he wanted to go that way, could he? So that was a very interesting episode, as are all the others. There's many cases he talks about. Thank you so much, everyone. I actually have to go. You know why? Because my earphones need to be charged, and I'm so sorry. So thank you, mods. Thank you, patrons. I really appreciate the deep dive we did the other day. If you are on Patreon or YouTube member, check out the community tab, the members only playlist, or Patreon. I've uploaded the video there for you and all the latest documents and everything, because we did a deep dive on that SWAT team situation. We speculated on the channel already, so go check that out. But damn, we went there and I showed you guys bloopers and all that. So go do that. All right. So thank you so much. And I will see you guys in the next one. Make sure you are subscribed with the bell on, okay? So that you don't miss when I next go live, especially when there's breaking news like that. I'm going to go deep dive that in a moment. And I'll see you in the next one. Okay, everyone. Bye.